Before we begin, it's critical to understand that the information in this video is for educational and informational purposes only. I am not a lawyer, and this presentation does not constitute legal advice. The world of law is complex and specific to your individual circumstances. Always consult with a qualified legal professional for advice regarding your particular situation. Imagine two best friends, let's call them Sarah and Mike. They're in a garage fueled by cheap pizza and a brilliant idea for a new software company. They work for a year straight coding, designing, and hustling. And it happens. Their app goes viral. Suddenly, they're not just two friends in a garage. They're sitting on a multi-million-dollar company. But they never signed a single piece of paper. They were best friends, they trusted each other. They just worked. Then they get their first offer to be acquired by a tech giant. The offer is $50 million. But the offer is only made to Sarah, because when they set up their web hosting, their bank account, their developer licenses, it was all done under her name. Legally, Mike doesn't exist. He has no claim. He is entitled to zero. Sarah walks away with $50 million, and Mike, who wrote half the code, is left with absolutely nothing. This isn't a plot from a movie. This kind of catastrophic business divorce happens every single day in America. And the only thing that could have saved Mike and ensured a fair outcome is the one subject most people think is the most boring, complicated topic on the planet: corporate law. But what if I told you that corporate law isn't boring? What if I told you it's actually the secret rulebook to the game of money, power, and innovation? What if I told you that understanding its basic principles is one of the most powerful skills you can develop, whether you want to start a business, climb the corporate ladder, or simply understand how the world around you actually works? That's the promise of this video. We are going to demystify corporate law. We're going to strip away the confusing jargon and the intimidating Latin phrases and reveal the simple, powerful concepts that form the bedrock of our entire economy. By the end of this, you won't be ready to take the bar exam, but you will understand the invisible architecture that shapes every major company you interact with, from Apple and Amazon to the local coffee shop on the corner. You'll know why a company can be sued but its CEO can't always be, why investors are willing to pour millions into a simple idea, and how to avoid the exact disaster that happened to Mike. So what is corporate law? At its core, it's shockingly simple. Think of business as a giant, high-stakes multiplayer game. Like any game from chess to football, it needs a set of rules to function. You need to know how the pieces move, what counts as a legal play, how to score points, and what happens when someone breaks the rules. Corporate law is that rule book. It's the set of laws, regulations, and practices that govern how businesses or corporations are created, how they are run, and how they are dissolved. It dictates the rights and responsibilities of everyone involved, from the billionaire founders to the individual shareholders to the employees on the front lines. But why do we even need this separate rulebook? Why can't a business just be a group of people working together? The answer to that question is one of the single most important inventions in human history, an idea so powerful it literally built the modern world. It's the concept of the corporate person. Now, stick with me here because this is where it gets interesting. Corporate law allows us to create a brand new, artificial person in the eyes of the law. This legal person is the company itself. Let's say you and I start a business called Apex Innovations. Under corporate law, Apex Innovations isn't just a name on a sign. It becomes its own entity, completely separate from you and me. Think about that for a second. This new entity, Apex Innovations, can do almost anything a real person can do. It can own property, it can buy buildings, cars, and computers in its own name, can enter into contracts, can borrow money from a bank, it can sue other companies or people if they wrong it, and crucially, it can be sued. This creates a powerful, almost magical shield called limited liability. And this is the first and maybe the most important reason corporate law exists. Because Apex Innovations is its own legal person. If the company goes into debt, the creditors can only go after the company's assets, its bank account, its property. They can't come after your personal house, your personal car, or your personal savings. Your liability, your financial risk, is limited to the amount you invested in the company. There's a corporate veil between the business's problems and your personal life. This is a game changer. Without limited liability, no sane person would ever take the risk to start a business. Can you imagine starting a car company, and if one of your cars had a defect and caused an accident, you could personally be sued for billions and lose everything you own? Nobody would do it. The entire modern economy, from skyscrapers to smartphones, is built on this foundational promise. We will give you a shield, so you can take big risks that create innovation, jobs, and progress. The second major reason for this rulebook is to organize ownership and investment. How do you own a piece of an idea? Corporate law provides the answer: through shares of stock. The law allows a company to divide its ownership into tiny little pieces, like a pizza cut into thousands or millions of slices. Each slice is a share. This system is pure genius because it allows founders to sell off pieces of their company to raise money, what we call capital, without losing complete control. An investor can buy some slices of the pizza, giving the company the cash it needs to grow, and in return that investor gets to share in the future profits. This is the engine of Silicon Valley and Wall Street. It's how a simple idea in a garage can attract millions of dollars and grow into a global empire. And third, corporate law provides a standardized structure for making decisions. It prevents the Sarah and Mike disaster. The rulebook says you need to define who is in charge. It creates a hierarchy. At the top, you have the shareholders, the owners of those pizza slices. They get to vote on the big stuff. They elect a team of supervisors to represent their interests, known as the board of directors. The board doesn't run the company day to day. Their job is to set the overall strategy and, most importantly, to hire and fire the top executives, like the chief executive officer or CEO. The CEO and their team of officers are the ones who actually run the company day to day. This structure, shareholders, board of directors, officers, creates a system of checks and balances. It ensures that someone is always accountable to someone else. It provides a clear roadmap for how decisions are made, how profits are distributed, and how disputes are resolved. It's the framework that allows thousands of people who may have never even met each other to work together towards a common goal. So, to recap, corporate law isn't just a pile of dusty books in a law library. It's a brilliant system designed to do three critical things. 1. Create a separate legal entity to provide a shield of limited liability, encouraging risk-taking and innovation. 2. Establish a clear and standardized way to raise money and define ownership through stock. And 3. Provide a stable, predictable structure for governance and decision-making. It's the operating system for modern capitalism. Now that we understand why this rulebook exists, to create a shield to raise money and to organize the players, we have to talk about the different kinds of shields you can choose. Because not all companies are created equal. The very first decision every founder makes, the decision that will impact their taxes, their liability, and their ability to grow, is choosing what kind of legal entity they want to be. It's like choosing your character class in a video game. Are you a nimble rogue, a sturdy tank, or a powerful mage? In the world of business, this choice comes down to a few acronyms you've definitely heard before: LLC, S Corp, C Corp. And understanding the difference between them is the first step from having an idea to building an empire. So let's break down these character classes. First up, the LLC, or Limited Liability Company. Think of this as the versatile warrior of the business world. The most popular choice for small businesses, and for a very good reason. The name gives away its superpower: limited liability. This is the magic shield. It creates a legal wall between your personal assets, your house, your car, your savings, and your business debts and lawsuits. If your coffee shop, set up as an LLC, gets sued because someone slips on a puddle, they can go after the business's bank account, but they can't come for your personal home. That shield is the single most important reason to form a business entity, instead of just operating as a sole proprietor. But the LLC is not just a tank. It's also incredibly flexible. It's simpler to set up and run than a corporation. It has fewer rigid rules and required meetings. And here's the best part for most small business owners. It has something called pass-through taxation. It sounds complicated, but the idea is simple. The LLC itself doesn't pay any income tax. Instead, the profits and losses pass through the business directly to you, the owner. You then report that income on your personal tax return. The business is not taxed, and then you are taxed again. There is only one layer of tax. It's clean, it's simple, and it's perfect for a freelancer, a small agency, a restaurant, or anyone who wants that ironclad shield of liability protection without a mountain of complicated paperwork. It's the go-to choice for a reason. Strong, simple, and effective. But what if you have bigger ambitions? What if you're not just looking to run a local shop, but to build a kingdom? What if you need to summon vast amounts of capital from powerful investors? Then you might need to become a mage. You need a corporation. Corporations are older, more formal, and in some ways more powerful than LLCs. They are seen as completely separate entities from their owners, not just in law, but in the eyes of investors and the public. They have a rigid structure with shareholders, a board of directors, and officers. This structure provides a clear chain of command and accountability, which is exactly what serious investors want to see before they write you a seven-figure check. But just like in our game, magic comes in different schools. And in the corporate world, this choice comes down to two letters, C or S. The C Corp versus the S Corp. Let's start with the default, the big one, the archmage, the C Corporation. When you hear about a company on the news going public with an IPO, or raising $100 million in venture capital, you are almost certainly hearing about a C Corp. Why? Because a C Corp has no restrictions on who can be an owner. Your shareholders can be anyone, anywhere in the world, even other companies. It can have an unlimited number of shareholders, and it can issue different classes of stock. This is crucial for investors. They might want preferred stock, which gives them special rights, like getting paid back first if the company fails, while founders and employees get common stock. This flexibility is the C Corp's superpower. It's the structure designed for massive scale and massive investment. But every great power comes with a great cost. And for the C Corp, that cost is a terrifying monster known as double taxation. Remember how the LLC had pass-through taxation, where profits were only taxed once on the owner's personal return. The C Corp is the exact opposite. Because the C Corp is a totally separate legal person, the IRS treats it that way. So first, the corporation itself pays corporate income tax on its profits. That's tax number one. Then, if the corporation decides to distribute some of those after-tax profits to its shareholders as dividends, the shareholders have to pay income tax on those dividends on their personal tax returns. That's tax number two. The same dollar of profit gets taxed twice, once at the corporate level and again at the shareholder level. This is the price of the C Corp's immense power and flexibility. For a small business, this can be a devastating blow. But for a high-growth startup that plans on reinvesting every single penny back into the business and not paying dividends for years, it's a price they're willing to pay for access to venture capital and the path to an IPO. So what if you want the formal structure of a corporation, but that double taxation curse sounds like a nightmare? What if you're a specialist who wants a different path? Then you might choose to be an S Corporation. The S Corp is the specialist mage. It's a bit of a hybrid. It starts its life as a regular corporation, but then it makes a special request to the IRS. It elects to be taxed under a special part of the tax code, subchapter S. And what does that special election do? It grants the S Corp pass-through taxation just like an LLC. The business itself pays no corporate income tax. The profits and losses pass through directly to the shareholders, and they pay tax just once on their personal returns. The S Corp slays the double taxation monster. So wait, you might be thinking, if the S Corp gives you the formal structure of a corporation and the tax benefits of an LLC, why doesn't everyone just choose that? Because special magic always comes with strict, unbending rules. The IRS is basically saying, okay, we'll grant you this powerful tax spell, but you have to follow our rules to the letter. And these rules are significant. An S Corp can have no more than 100 shareholders. All of those shareholders must be actual human beings, not other corporations or partnerships, and they must be U.S. citizens or permanent residents. And critically, an S Corp can only have one class of stock. Everyone gets the same type of share with the same rights. This immediately makes it a non-starter for most venture capitalists, who demand the special rights that come with preferred stock. So the S Corp is a fantastic tool for certain types of businesses, often profitable, established companies with a small group of US-based owners who want to take money out of the company in a tax-efficient way. But it closes the door on the kind of massive global investment that C Corp are built for. So let's put it all together. Choosing your business entity is choosing your path. Do you want to be the LLC, the versatile warrior with a great shield, simple armor, and a straightforward attack, perfect for most adventures? Do you want to be the S Corp, the specialist mage who masters one powerful spell, avoiding double taxation, but must adhere to a strict code that limits who can join your party? Or do you want to be the C Corp, the archmage who has the potential for limitless power, capable of building a vast guild and attracting the most powerful patrons, but must live with a constant, draining tax curse? This isn't just a thought exercise. This decision, made right at the beginning, will dictate your company's entire journey. It affects how you pay yourself. It affects your ability to bring on partners. It fundamentally changes your relationship with taxes. And most importantly, it erects that legal shield between your business and your life. But here's the critical question that nobody thinks about when they're just starting. What happens if that shield breaks? Because it can. That limited liability, that magical wall we talked about? It's not absolute. There's a legal concept known as piercing the corporate veil. And it's exactly what it sounds like. It's a way for courts to ignore your LLC or corporation and come directly after your personal assets. And the reasons it can happen are all based on the simple, boring, day-to-day rules you're supposed to follow after you've formed your company. Creating the entity is just the first step. Maintaining it is the real quest. And failing to do so can leave your personal kingdom in ruins. So how exactly does the castle crumble? How does that magical shield you spent time and money creating suddenly shatter, leaving you exposed on the battlefield of business? It happens through a legal doctrine with a name that sounds as dramatic as it is: piercing the corporate veil. Imagine that limited liability shield we talked about is a literal, physical veil separating your business world from your personal world. On one side you have your company, its assets, its debts, its obligations. On the other side you have everything else: your house, your personal savings account, your car, your kids' college fund. As long as that veil is intact, a creditor who wins a lawsuit against your business can only touch what's on the business side of the veil. They are legally blocked from reaching across and grabbing your personal assets. This is the entire point of forming a corporation or an LLC. But piercing the veil is what happens when a court decides to rip that veil down. A judge essentially declares, "You know what? I don't see two separate things here. I don't see a person and a company. I see one and the same. This company is just a mask, a puppet, a ghost." So the protection is gone. And just like that, the shield evaporates. The lawsuit that was just against your business is now a lawsuit against you personally. Your home, your savings. Everything is now on the table to satisfy the company's debt. This is the corporate law equivalent of a nuclear option. It's the single greatest fear of every small business owner. And it happens far more often than you think. So why would a court ever do this? Why would it undo the very protection that the law is designed to provide? The primary reason is fairness. The shield of limited liability is a privilege, not an absolute right. And you lose that privilege when you abuse it. The most common way this happens is through what's called the alter ego doctrine. The court determines that the corporation isn't a separate legal entity at all. It's merely the alter ego of its owner. You haven't been treating the company like a separate person, so why should the law? To understand this, let's invent a character. Let's call her Sarah. Sarah is a talented graphic designer who decides to start her own freelance business. She's smart, so she goes online, fills out the forms, and creates Sarah's Designs LLC. She gets her official documents from the state, she opens a business bank account, and she feels a huge sense of relief. She has built her castle. She is protected. But then she starts making a few seemingly small mistakes. First comes the sin of commingling funds. This is by far the #1 killer of corporate veils. One week, business is a little slow. Sarah's personal rent is due, but her personal checking account is a little low. She thinks, "No big deal, I'll just pay it directly from the business account. I'm the only owner, who's going to care? I'll pay it back later." So she writes a check to her landlord from the Sarah's Designs LLC account. A few weeks later, she's at the grocery store and realizes she left her personal debit card at home. Annoyed, she just uses her business debit card to buy a week's worth of groceries. She tells herself she'll sort it all out at the end of the year. What Sarah doesn't realize is that she's committing a cardinal sin of corporate law. She is blurring the line. She is treating the company's bank account as her own personal piggy bank. Every time she does this, she is handing a future plaintiff's lawyer a piece of ammunition. That lawyer will later stand up in court and say, "Your Honor, Sarah herself didn't treat this LLC as a separate entity. She used its money for her rent, for her food, for her personal life. She used it as an extension of her own wallet. If she didn't respect the separation, why should we?" With every personal transaction, Sarah is personally tearing a small hole in her own corporate veil. Next, Sarah commits the sin of ignoring corporate formalities. When she formed her LLC, the operating agreement she downloaded, and probably didn't read very closely, said that the company should hold annual meetings and keep records or minutes of those meetings. Sarah scoffs at this. "Annual meeting? I'm the only member. Am I supposed to have a meeting with myself in my living room? That's ridiculous." So she doesn't. She never writes anything down. She signs a huge contract with a new client, but she just signs it Sarah. Not Sarah, president of Sarah's Designs LLC. She doesn't keep resolutions authorizing big business decisions. To her, this is all just pointless bureaucratic paperwork for giant companies like Apple or Ford, not for her one-woman design shop. But she's dangerously wrong. These formalities, as boring and silly as they may seem, are the rituals that prove to the outside world that your company is a real, separate entity. They are the evidence. Holding an annual meeting, even with yourself, and writing down, on this day, the sole member of the LLC met and agreed to purchase a new computer for the business, creates a paper trail. It's you, performing the role of business owner, and demonstrating to the world that you respect the corporate form. When you skip these steps, a lawyer can argue, Your Honor, this wasn't a real company. There are no meeting minutes, no resolutions, no proper records. It was just a name on a piece of paper that Sarah used when it was convenient. It was a sham. Each skipped formality is another tear in the veil. Finally, Sarah makes a third, more subtle mistake: undercapitalization. When she started her business, she put exactly $100 into the business bank account. Just enough to get it open. Her business doesn't have a lot of overhead, so she figures that's fine. She never buys business insurance like liability insurance because it feels like an unnecessary expense. The business owns a laptop and that's about it. It has virtually no assets of its own. Now let's imagine disaster strikes. Sarah creates a logo and marketing campaign for a new beverage company, but she unknowingly uses an element that is trademarked by a massive, litigious competitor. That competitor sues Sarah's client and Sarah's Designs, LLC for trademark infringement. The court finds in their favor and awards them $200,000 in damages. The beverage giant's lawyers turn to Sarah's LLC for payment. They look at the company's bank account and find a few $1,000s. They look at its assets and find a used laptop. The company is essentially broke. It was never capitalized with enough money or insured to handle the potential risks of its own business operations. This is where a court might get very angry. The judge might see this as fundamentally unfair. The whole point of a business is to operate in the world and pay its debts. By creating a company with no money and no insurance to cover its foreseeable risks, Sarah has created what some courts call a judgment-proof entity. She's set up a system where she can reap all the rewards if things go well. But if things go badly, her company can't pay its bills, and the victims are left with nothing. In this situation, a court is highly motivated to pierce the corporate veil. They will say that setting up a corporation with no money to back it up is a fraud on creditors. It's an abuse of the corporate privilege. And so they will tear down that final tattered remnant of her veil. And suddenly, all three of Sarah's mistakes, commingling funds, ignoring formalities, and undercapitalization, come crashing down on her at once. The beverage company's lawyers are no longer just suing her LLC. They are suing her. That $200,000 judgment isn't against her business anymore. It's against her personally. They can now go after her personal savings account. They can put a lien on her house. They can garnish her future wages. Her entire personal kingdom is now at risk of being turned into ruins, all because she failed to maintain the simple, boring day-to-day rules that keep the castle walls strong. This is the brutal reality of corporate law. The entity itself is just the beginning. The true test is in the discipline of treating it like the separate legal person it's supposed to be. It means having separate bank accounts and never mixing them. It means signing documents with your proper corporate title. It means documenting major decisions. It means funding your business with enough capital and insurance to be a responsible participant in the economy. These aren't just best practices. They are the very essence of your protection. But protecting yourself from the outside world is only half the battle. What about the rules that govern the people inside the castle? The relationships between the founders, the investors, the managers? What happens when the owners disagree? Who actually has the power to make decisions? That brings us to the internal architecture of the corporation. The intricate dance between shareholders, directors, and officers. This internal architecture is the constitution of the corporation, a system of checks and balances designed to align the interests of millions of different people. And it's built on three key pillars: the shareholders, the board of directors, and the officers. If you want to understand corporate law, you have to understand this power triangle. The simplest way to think about it is to compare it to the US government. It's not a perfect one-to-one match, but it's an incredibly useful mental model. In this analogy, the shareholders are the citizens, the voters. The board of directors is the legislature, like Congress. And the officers, the CEO, CFO, and so on, are the executive branch, the president and their cabinet. Let's start with the shareholders. These are the owners of the company. If you own a single share of Apple stock, congratulations, you are a part owner of Apple. You are a shareholder. But what does that ownership actually get you? You can't just walk into Apple Park and start telling Tim Cook what to do. Your power, much like a single voter's power in a national election, is indirect but fundamental. Shareholders have a few critical rights. First and foremost, they have the right to vote. This is their primary mechanism of control. What do they vote on? The most important vote they cast is for the members of the board of directors. Just like citizens elect representatives to go to Washington to make decisions on their behalf, shareholders elect directors to sit in the boardroom and make decisions for the company. This election typically happens once a year at the annual shareholder meeting. They also get to vote on truly massive, company-altering decisions. Think of these as constitutional amendments for the corporation. Things like selling the entire company to a competitor, merging with another giant corporation, or dissolving the company altogether. These aren't day-to-day business choices. They are fundamental changes to the corporation's very existence. Beyond voting, shareholders have a right to information. They have a right to inspect the company's books and records to make sure everything is being run properly. And, of course, they have a right to their share of the profits, which are usually distributed as dividends. But here's the crucial trade-off. In exchange for this indirect power, they get the ultimate protection we talked about earlier: limited liability. A shareholder's risk is capped at the amount they invested. If the company goes bankrupt owing billions, the creditors can't come after your personal savings account. You lose the money you paid for the stock, and that's it. So, limited power but also limited risk. They are the owners, but they delegate the actual running of the show to our next group, the board of directors. Now, if the shareholders are the voters, the board of directors is the legislature. They are the elected representatives. A typical board might have anywhere from 5 to 15 members, and their job is not to manage the day-to-day grind. Their job is to provide high-level oversight and set the broad strategic direction of the company. They are the ones who answer the 50,000-foot questions. Should we expand into the European market? Should we invest $1 billion in developing artificial intelligence? Should we acquire that promising young startup? They approve the annual budget. They decide whether to issue dividends to the shareholders. And most critically, the board of directors has the power to hire and fire the most important employee in the entire company, the chief executive officer, or CEO. This is the board's ultimate check on power. The CEO runs the company, but they serve at the pleasure of the board. The board is their boss. Because the board holds so much power on behalf of the shareholders, corporate law imposes on them some very serious legal obligations, known as fiduciary duties. This is one of the most important concepts in all of corporate law. A fiduciary duty is a legal and ethical obligation to act in the best interest of another party. In this case, the directors must act in the best interest of the corporation and its shareholders. These duties primarily break down into two big ideas: the duty of care and the duty of loyalty. The duty of care means directors have to be diligent. They have to show up, do their homework, read the reports, ask smart questions, and make informed decisions. They can't just be asleep at the wheel. The law doesn't require them to be business geniuses who are always right, but it does require them to be prudent and careful, like any reasonably sensible person would be in managing their own affairs. Then there's the duty of loyalty. This is even more fundamental. The duty of loyalty means the director's primary allegiance must be to the corporation. They cannot use their position to enrich themselves at the company's expense. They must avoid conflicts of interest. For example, a director can't vote to have the corporation sign a massive, overpriced contract with a construction company that the director secretly owns. That would be putting their personal financial interests ahead of the corporation's interests. A classic breach of the duty of loyalty. These fiduciary duties are the legal guardrails that keep the directors accountable to the shareholders who elected them. So the shareholders elect the directors, and the directors set the strategy and hire the CEO. That brings us to the third pillar: the officers. If the board is the legislature, the officers are the executive branch. They are the professional managers who run the company day to day. The head of this branch is the CEO, who is like the president. Then you have the rest of the C-suite, the chief financial officer (CFO), who manages the money, the chief operating officer (COO), who manages the internal operations, and so on. They are the cabinet. The officers are the ones who execute the strategy that the board sets. The board might say, "Our strategic goal for the next 5 years is to become the leader in the electric vehicle market." It's the CEO and the officers who then have to figure out how to actually do that. They hire the engineers, build the factories, design the marketing campaigns, and manage the thousands of employees who make it all happen. They are the hands-on leaders, the ones on the ground making thousands of decisions every week. And just like the directors, the officers are also fiduciaries of the corporation. They too owe the company a duty of care and a duty of loyalty. They are employees of the company, and their job is to implement the board's vision and create value for the shareholders. So let's see how this all works together with a quick, practical example. Imagine a public company. Let's call it Future Gadgets Incorporated. The officers, led by the CEO, notice a new trend in wearable technology. They spend months developing a business plan to create a revolutionary new smartwatch. This is the executive branch doing its job. The CEO then takes this plan to the board of directors. She presents the market research, the development costs, the projected profits, and the risks. The board, our legislature, then exercises its duty of care. They debate the plan. They question the CEO's assumptions. They bring in outside experts to verify the technology. After thorough deliberation, they vote to approve the project and authorize the $50 million budget. They have set the policy. Now the plan goes back to the officers to execute. The CEO, CTO, and their team spend the next year building, marketing, and launching the new smartwatch. And where are the shareholders, the voters, in all of this? They don't vote on the smartwatch. That's an operational decision, delegated to the directors and officers. But their presence looms over everything. If the smartwatch is a huge success, the company's profits soar, the stock price skyrockets, and the shareholders are rewarded. They will likely re-elect the current board of directors at the next annual meeting. But if the smartwatch is a catastrophic failure that loses millions of dollars, the shareholders might get angry. They might vote to throw out the board of directors and elect a new slate of directors who promise to hire a new CEO and change the company's direction. This is the system in action. Shareholders provide the capital and elect the board. The board provides oversight and hires the officers. The officers manage the business to create profit for the shareholders. It's a circular flow of power and accountability. In theory, it's a beautiful self-regulating system. But this elegant structure is also filled with potential for conflict and failure. What happens when a CEO starts treating the company like a personal piggy bank? What happens when the board is too cozy with the CEO to properly oversee them? What happens when a powerful group of shareholders tries to force a decision that's good for them in the short term, but terrible for the company in the long run? This is where the system breaks down, and where corporate law truly gets interesting. It's in these moments of crisis that the rules really matter. So let's put this to the test. Imagine a company, let's call it Innovate Corp. For years, Innovate Corp has been a leader in its field, known for its slow, steady, methodical research and development. It invests heavily in its employees and prioritizes long-term, groundbreaking projects over quick quarterly profits. Its stock price is stable, but not spectacular. The shareholders are generally happy, but they aren't getting rich overnight. Then one day the sharks start circling. A new player enters the scene, a so-called activist investor, or what used to be called a corporate raider. Let's call him Rex Capital. Rex Capital sees Innovate Corp not as a hub of innovation, but as a lazy, undervalued asset. They see all that money being spent on long-term research as waste. They see the happy, well-paid employees as an expense to be cut. They look at the company's assets, its patents, its buildings, its technology, and think, we could sell all this off for parts and make a fortune. Rex Capital decides it wants to take over Innovate Corp. But the board of directors at Innovate Corp, led by its visionary founder, immediately says no. They know Rex Capital will dismantle everything they've spent decades building. They refuse to even meet. This is the flashpoint. This is a hostile takeover attempt. It's hostile because the target company's management and board do not want the deal to happen. So, if the board won't sell, how can Rex Capital possibly buy the company? Simple. They go over the board's head. They go directly to the true owners, the shareholders. Rex Capital initiates what's called a tender offer. This is a public offer, announced in the Wall Street Journal on financial news networks everywhere. The offer is simple and incredibly tempting. To all shareholders of Innovate Corp, we, Rex Capital, will buy every single one of your shares for $40. Now here's the catch. Innovate Corp stock has been trading at around $30 for the past year. Rex Capital is offering a massive premium. They're offering you, the shareholder, a huge immediate cash payout. All you have to do is tender, or turn in your shares. If they can get enough shareholders, usually over 50%, to agree, they will effectively own the company. They can then fire the old board, install their own people, and do whatever they want. This creates the ultimate dilemma we talked about. You're a shareholder. Maybe you're a pension fund managing retirement money for teachers, or maybe you're just a regular person who invested your savings. You believe in Innovate Corp's long-term vision. But $40 a share is a lot of money. That's a 33% profit right now in your pocket. Do you take the guaranteed cash, or do you gamble on the company's long-term future, which might not pay off for years, if ever? What if you say no but everyone else says yes? Then the company gets taken over anyway, and you're stuck with a stock that might plummet under new, ruthless management. The pressure to sell is immense. This is corporate warfare. And the board of directors isn't just going to sit there and let it happen. Corporate law provides them with an entire arsenal of defensive weapons, and some of them have the most incredible names. The most famous, most powerful defense is the poison pill. It sounds like something out of a spy movie, and it works in a similarly dramatic fashion. A poison pill is technically called a shareholder rights plan, but nobody calls it that because poison pill is way cooler. Here's how it works. The board, often long before any takeover is ever attempted, adopts a policy. The policy says that if any single entity, like Rex Capital, acquires a certain percentage of the company's stock, say 15%, without the board's approval, the pill is triggered. The moment Rex Capital crosses that 15% threshold, something incredible happens. Every other shareholder suddenly gets the right to buy newly issued shares of Innovate Corp at a massive discount, sometimes 50% off the market price. Think about the effect of that. Millions of new shares flood the market, all bought on the cheap. This is called dilution. For Rex Capital, the result is catastrophic. Their 15% stake, which they spent billions to acquire, is suddenly diluted down to maybe 8% or 9% of the newly expanded pool of shares. The value of their investment is instantly and massively crushed. It makes continuing the takeover attempt prohibitively expensive. It's a self-destruct mechanism that only poisons the attacker. It's the corporate equivalent of saying, "You can capture our castle, but the moment you step inside, we blow up the whole thing." The poison pill is the nuclear option. But there are other, more subtle defenses. There's the staggered board, also known as a classified board. On a normal board, all the directors are up for election every year. So if you get 51% of the vote, you can kick them all out and take control instantly. But on a staggered board, the directors are divided into classes, usually 3. Only 1/3 of the board is up for election each year. This means that even if Rex Capital managed to buy 51% of the stock, they could only replace 1/3 of the board in the first year. They'd have to wait a whole other year to replace the next third, and a third year to finally get full control. It's a brilliant delay tactic. It forces the attacker to be patient and gives the company precious time to come up with a better plan. What other plans? Well, they can go looking for a white knight. If you're going to be acquired, you might as well be acquired by someone you like. The board of Innovate Corp could desperately search for a friendly company, let's call them Future Vision Incorporated, that shares their values and long-term vision. They can then negotiate a friendly merger with Future Vision, who will often agree to pay an even higher price than the hostile bidder, saving the company from the clutches of the corporate raider. They can also use the Just Say No defense, launching a massive public relations campaign to convince shareholders that the raiders offer, while tempting, is a lowball price that doesn't reflect the true long-term value of the company. They'll argue that if shareholders just hold on, that $30 stock will be worth $100 in 5 years because of the amazing projects in the pipeline. We saw this play out in the real world just recently. When Elon Musk first tried to buy Twitter, the company's board was not interested. They viewed his offer as a hostile bid. And what was the first weapon they reached for? The poison pill. They adopted a plan that would trigger if he acquired more than 15% of the company, a classic defensive maneuver designed to force him to the negotiating table or walk away. All of these tools, the poison pill, the staggered board, the white knight, are incredibly powerful. They can absolutely stop a hostile takeover dead in its tracks. And this brings us to the most fundamental question in all of corporate governance, a question that courts have struggled with for decades. When a board of directors uses these powerful defenses, are they acting in the best interests of the corporation and its shareholders? Or are they just trying to protect their own jobs? Think about it. The board is saying no to a deal that would give their shareholders a massive, immediate profit. They claim it's to protect the company's long-term future. But it also conveniently protects their own high-paying prestigious positions as directors. If the company is sold, they're all out of a job. So how can we, or the courts, know if they are truly being noble guardians of the company's vision, or just self-interested managers trying to entrench themselves in power? This is the core conflict, the legal gray area where billion-dollar lawsuits are born. And to answer it, we have to understand the single most important concept in corporate law: the fiduciary duty. So what is this fiduciary duty? In the simplest terms, it's a duty of trust. It's the highest standard of care the law can impose on someone. Think about it like this. When you go to a doctor, you trust them to act in your best interest, not the interest of the pharmaceutical company that gives them free samples. When you hire a lawyer, you trust them to fight for you, not to cut a side deal with the opposing counsel. That relationship of trust, that's a fiduciary relationship. In corporate law, the directors and officers have a fiduciary duty to the corporation and its shareholders. This means they are legally obligated to put the company's interests ahead of their own. It's the fundamental promise that keeps the whole system from collapsing into a swamp of self-interest. This duty isn't just one vague idea. It's broken down into two core pillars, two commandments that every director and officer must follow: the duty of care and the duty of loyalty. Let's start with the duty of care. This is the don't be lazy rule. It requires a director to act with the care that a reasonably prudent person in a similar position would use under similar circumstances. Now, that sounds like a mouthful of legalese, but the concept is simple. It's not about being a genius. You don't have to be Warren Buffett. You don't have to predict the future perfectly. The law doesn't punish you for making a bad business decision. Business is all about taking risks, and sometimes those risks don't pay off. What the duty of care punishes is making a decision negligently. It's about the process, not the result. Did you do your homework? Did you read the reports? Did you ask questions? Did you attend the meetings? Did you actually try? The most famous case that illustrates this is a story of a massive company sale that was decided in less time than it takes to watch a movie. It's the case of Smith v. Van Gorkum. The company was TransUnion, a big credit reporting agency. Its CEO, Jerome Van Gorkum, was nearing retirement and wanted to sell the company. He secretly negotiated a deal to sell TransUnion for a specific price per share. He then called a surprise board meeting. He gave a 20-minute oral presentation on this massive company-altering deal. He didn't give the board members a written summary of the terms. They didn't have a copy of the merger agreement to review. They had no documents, no prior warning, and no independent valuation to tell them if the price was even fair. After just a 2-hour meeting, the board approved the sale. Later, the shareholders sued, arguing the board breached its duty of care. And the court agreed. The court didn't say the price was bad. The court didn't say selling the company was a bad idea. What the court said was that the process was a disaster. The directors were, in the court's words, grossly negligent. They failed to inform themselves. They acted in haste, and without any real deliberation. They didn't do their homework. And as a result, they were held personally liable for millions of dollars in damages. The duty of care, then, is about being engaged, informed, and diligent. It's the baseline level of competence we expect from the people steering a billion-dollar ship. But competence isn't enough. You can be the smartest, most diligent director in the world, but if your heart is in the wrong place, you're in even bigger danger. That brings us to the second pillar, the duty of loyalty. If the duty of care is about competence, the duty of loyalty is about character. It is the most important duty, and it demands one thing: that the director acts in the best interest of the corporation, not in their own personal interest. It's about undivided loyalty. It's the don't be crooked rule. This duty is designed to fight the most corrosive force in business: conflicts of interest. A conflict of interest arises whenever a director has a personal stake in a transaction the company is making. The law breaks these conflicts down into a few categories. The most obvious one is called self-dealing. This is when a director is on both sides of a deal. Imagine a director on the board of Boeing. That director also happens to own a company that manufactures airplane seats. The director convinces the Boeing board to sign an exclusive contract to buy all its seats from his company at a price that's 30% above the market rate. Who wins? The director's seat company. Who loses? Boeing and its shareholders, who are now overpaying for seats. The director put his own financial interest, selling his seats for a high price, ahead of the corporation's interest, getting the best deal on seats. That is a classic breach of the duty of loyalty. Another major breach is the usurpation of a corporate opportunity, which is a fancy way of saying stealing a business deal. Let's say you're a director at a real estate development company. In a board meeting, you learn that the company is planning to buy a specific plot of land to build a new shopping mall. You know it's a golden opportunity. So, before the company can act, you secretly go out and buy the land for yourself. You then turn around and offer to sell it to the company for a huge profit. You've used your inside knowledge and your position to snatch an opportunity that rightfully belonged to the corporation. You put your personal gain ahead of the company's, and you violated your duty of loyalty. So you have these two massive duties. Be diligent and be loyal. Sounds terrifying. If you're a director and you vote for a merger that ends up failing, can you be sued for breaching the duty of care? If you approve a new product line that flops, are you on the hook for the losses? If this were the case, no sane person would ever agree to be a director. No one would ever take a risk. And business is all about taking risks. To solve this problem, the law created a powerful shield for directors. It is arguably the single most important and most litigated doctrine in all of corporate law. It's called the business judgment rule. The business judgment rule is a legal presumption. It says that as long as a director was disinterested, meaning they didn't have a conflict of interest, and was reasonably informed, the court will not second-guess their decision, even if it turns out to be a total disaster. The court essentially says, we are judges, not business experts. It is not our job to Monday morning quarterback your decisions. As long as you followed a reasonable process and your intentions were pure, we will not interfere. This rule is what allows innovation. It's what allows a company like Apple to bet the farm on a crazy new device called the iPhone. It's what allowed Coca-Cola to launch New Coke, even though it became one of the biggest marketing blunders in history. The directors who approved New Coke weren't sued and held liable, because they had a good process. They did market research, they did taste tests, they genuinely believed it was a good business decision. They were wrong, but they weren't negligent or disloyal. Their decision was protected by the business judgment rule. But look at the TransUnion board, who sold their company in 2 hours. Were they protected? No. The court said the business judgment rule shield only protects you if you were reasonably informed. Because the TransUnion board was grossly negligent in how they informed themselves, the shield shattered, and they were left exposed to liability. Think of it this way. The duties of care and loyalty are the gateways. You have to pass through them first. You have to prove you did your homework and that you weren't acting out of self-interest. If you can do that, you are granted the powerful protection of the business judgment rule. Your decisions, good or bad, will be respected. This entire framework, the duty of care, the duty of loyalty, and the business judgment rule, is the legal system's brilliant, if imperfect, answer to the agency problem. It's the set of rules designed to make sure that the people in the cockpit are flying the plane for the benefit of the passengers, not just themselves. It governs the internal battles, the boardroom dramas, and the decisions that shape the fate of our largest corporations. But these rules primarily deal with the threats from within. They police the managers and directors already in power. But what happens when the threat comes from the outside? What happens when a corporate raider, a titan of Wall Street with billions at his disposal, decides he wants to buy your company, whether you want to sell it or not? This is the world of hostile takeovers, poison pills, and white knights, the high-stakes corporate warfare that defined an entire era of American business. And that is where our story goes next. Imagine you're the CEO of a company you've spent your life building. You wake up one morning, grab your coffee, and turn on the financial news. And there it is. A headline that makes your heart stop. A notorious corporate raider, a titan of Wall Street, has just announced they've bought up a huge chunk of your company's stock. And they've made a public offer to buy all the rest, at a price well above what it's currently trading for. They didn't call you. They didn't ask for a meeting with your board. They went straight to your owners, the shareholders, and offered them a big pile of cash. Your company is officially in play. You are under siege. This isn't a friendly merger. This is a hostile takeover. It's a battle for the soul of a corporation, fought not on a battlefield, but on the floor of the stock exchange and in the backrooms of the most powerful law firms in the country. The raider, often called a Black Knight, sees your company not as a living, breathing entity, but as a collection of assets. They believe your company is undervalued. Maybe they think your management is inefficient, or that you're sitting on valuable divisions that could be sold off for a massive profit. They see a juicy target, a financial prize to be conquered. Their plan is simple. Buy enough shares to gain a controlling interest, fire the existing board and management, that means you, and then do whatever they want with the company. They might break it up and sell it for parts in a move called asset stripping. Or they might load it up with debt to finance the purchase itself, a strategy known as a leveraged buyout. So how do they do it? The most common weapon is the tender offer. It's that public offer to buy shares directly from the shareholders at a premium. Let's say your stock is trading at $50 a share. The raider comes in and offers to buy every share for $70. For a shareholder, this is incredibly tempting. Do they stay loyal to your long-term vision, or do they take the guaranteed $20 profit right now? The raider is essentially trying to bribe your army of shareholders to open the castle gates for them. But you and your board are not helpless. This is where corporate law gets creative, even theatrical. Your lawyers, the true generals in this war, will advise you to deploy a series of defenses known as shark repellents. And the most famous, most powerful of these is the poison pill. A poison pill is one of the most brilliantly diabolical inventions in corporate finance. Officially called a shareholder rights plan, it's a defensive strategy designed to make your company incredibly difficult or painfully expensive to swallow. Here's how it works in its most common form. The board issues special rights to all its existing shareholders. These rights are worthless at first. They just sit there. But they are programmed with a trigger, usually when an hostile acquirer buys a certain percentage of the company's stock, say 15%. The moment the raider crosses that 15% threshold, the pill is triggered. The poison is released. Suddenly, those rights held by every other shareholder become active. They now give every shareholder, except the raider, the right to buy newly issued shares of the company at a massive discount, often half the market price. Think about the effect. Everyone rushes to buy these super cheap shares. The market is instantly flooded with millions of new shares. This is called dilution. The raider's 15% stake, which they spent billions to acquire, is suddenly diluted down to maybe 8% or 5%. Their voting power is crushed. To get back to a controlling stake, they would have to spend exponentially more money, buying up a sea of newly created stock. It makes the takeover so astronomically expensive that it's usually not worth it. The pill poisons the deal. But what if the poison pill isn't enough, or the board is hesitant to use it? They might go in search of a white knight. If you're going to be taken over, maybe it's better to be taken over by a friend. The board will actively seek out a different, more friendly company to acquire them instead. This white knight rides in, makes a higher, better offer than the hostile raider, and rescues the company. Of course, the company still loses its independence, but it gets to choose its new owner, one who might promise to keep the company intact, protect jobs, and respect its culture. The defenses get even more aggressive. There's the Pac-Man defense, named after the video game. This is the ultimate no-you move. The target company, the one under attack, turns around and tries to acquire the hostile raider. It's an incredibly risky and expensive long shot, like a gazelle trying to eat the lion that's hunting it, but it has been successfully used. Then there are golden parachutes, which are massive severance packages guaranteed to top executives if they're fired after a takeover. The idea is to make firing the leadership team so expensive that it deters the raider. Now, you might be thinking, can the board just do whatever it wants? Can they deploy a poison pill that denies shareholders a huge profit from the raider's offer? This is the central legal question, and it all comes back to fiduciary duty. The board must act in the best long-term interests of the shareholders. A raider will argue that their high-priced offer is in the shareholders' best interest, and that the board is just using poison pills to protect their own jobs. The board will argue that the raider's short-term price is less valuable than the company's long-term, independent future. These battles are almost always fought in court, most famously in the Delaware Court of Chancery, the most important business court in the nation. Over decades of high-stakes takeover battles, the courts have laid down the rules of engagement. One of the most critical is the Revlon rule, stemming from a famous 1986 case. It essentially says that once a company's breakup or sale becomes inevitable, the board's duty changes. The goal is no longer to preserve the company's independence. The board's sole primary duty becomes that of an auctioneer, to get the absolute highest possible price for the shareholders. They can't play favorites with a white knight if the hostile raider is offering more cash. This entire era of corporate warfare, which peaked in the 1980s, created legends. Men like Carl Icahn and T. Boone Pickens became household names. To their supporters, they were shareholder activists, heroes who forced lazy, bloated, and inefficient corporate boards to be accountable. They unlocked value and put money back in the pockets of the average investor. To their detractors, they were predators, vultures who destroyed perfectly good companies, loaded them with crippling debt, and laid off thousands of workers, all for a quick profit. The truth, as always, is probably somewhere in the middle. This high-stakes game of acquisitions, mergers, and defenses is one of the most dramatic and complex arenas of corporate law. It's where legal strategy, financial engineering, and human psychology collide. The lawyers aren't just advisors, they are the architects of attack and defense, crafting the poison pills and structuring the white knight rescues. But winning this war can come at a tremendous cost. Sometimes the debt taken on to fend off a raider or to finance a white knight deal can leave a company weak and vulnerable. And sometimes, whether through a takeover or just bad business, a company finds itself on the edge of a cliff, unable to pay its debts, with the entire enterprise at risk of disappearing completely. What happens then? What happens when the money runs out? That's when corporate law enters one of its most critical phases, the world of bankruptcy. The word bankruptcy conjures up images of failure, of boarded-up storefronts and everything must go signs. And while it can be the end of the road, it's far more complex and frankly more fascinating than that. Corporate bankruptcy law isn't designed to punish a company for failing. In fact, it's the opposite. It's a system designed to give a struggling company one of two things: a second chance at life, or a dignified, orderly death. Think of it like a corporate emergency room. When a company is bleeding cash, can't pay its bills, and is on the verge of flatlining, it can't just throw its hands up and walk away. Why not? Because there's a long line of people and other companies it owes money to, the creditors. You have the banks that gave it loans, the suppliers who shipped it parts on credit, the landlords of its offices, and maybe even thousands of bondholders. If the company just collapsed, it would be a chaotic free-for-all. The strongest, fastest creditors would swoop in and grab whatever assets they could, leaving everyone else with nothing. It would be pure chaos. To prevent this, the company, or sometimes its creditors, can petition a special federal court, the bankruptcy court. The moment that petition is filed, something incredible happens. It's called the automatic stay. This is a legal shield that immediately slams down around the company, freezes everything. Creditors can no longer sue the company, they can't repossess property, they can't even make angry phone calls demanding payment. The automatic stay forces everyone to take a deep breath and step back. It creates a calm, controlled environment where the fate of the company can be decided under the supervision of a judge. From this point, the path typically diverges into two main roads, named after chapters in the U.S. Bankruptcy Code. The first and most famous is Chapter 11. Chapter 11 is the reorganization. This is the second chance. This is the company saying, "We have a viable business here, but our finances are a complete mess. We have too much debt, our costs are too high, but the core idea of what we do is still good. We need help to fix it." A classic, almost unbelievable example of this is Marvel Comics. In the mid-1990s, the home of Spider-Man and the X-Men was on the brink of collapse, filing for Chapter 11 bankruptcy. The company was a mess. But under the protection of the court, Marvel was able to restructure. It got new leadership, shed unprofitable parts of its business, and developed a new plan. That plan, in part, involved taking a huge gamble, making their own movies instead of just licensing their characters to other studios. The result was the Marvel Cinematic Universe, one of the most successful media franchises in human history. That comeback, that global empire, was born from the ashes of a Chapter 11 bankruptcy. During a Chapter 11, the company's existing management usually stays in place, a concept called debtor in possession. They continue running the day-to-day business, but now they have a monumental task. They must create a reorganization plan. This plan is the blueprint for survival. It details how the company will become profitable again. It might involve closing stores, laying off employees, renegotiating contracts, or selling off entire divisions. Most importantly, it proposes how the company is going to deal with all its creditors. And this is where the real fight begins. The company has to convince its creditors to accept the plan. It's a brutal negotiation. They might say to a bank, "We owe you $10 million. We can't pay that. But under our new plan, we can pay you $6 million over the next 5 years. If you don't take this deal, the company will fail completely, and you'll get nothing." The creditors form committees, hire their own lawyers, and fight to get the best deal possible. They vote on the plan, and ultimately a bankruptcy judge has to approve it, ensuring it's fair and feasible. If the plan is approved, the company emerges from bankruptcy leaner with less debt and ready for that second chance. But what if a second chance isn't possible? What if the company is just too broken to be fixed? That's the second road. Chapter 7 Bankruptcy. Chapter 7 is liquidation. This is the orderly death. This is the court, the company, and the creditors all agreeing that there is no viable business left to save. The goal is no longer to keep the company alive, but to sell off everything it owns in the fairest way possible to pay back as much debt as possible. Think of Blockbuster Video or Toys R Us. Their business models were fundamentally broken by new technology and changing consumer habits. No amount of restructuring could save them. In a Chapter 7, the court appoints a trustee. This person's job is to take control of the company. The CEO, the board, they're all out. The trustee is now in charge, and their mission is simple. Conduct a corporate funeral. They must gather up all the company's assets, its buildings, its inventory, its patents, its vehicles, its cash, and sell them for the highest possible price. The money raised from this massive sale is then put into one big pot. And now we get to the most painful part, dividing that pot of money. There is almost never enough money to pay everyone back what they're owed. So, corporate law has a very strict hierarchy, a pecking order for who gets paid first. This is called the absolute priority rule. At the very top of the list are secured creditors. These are lenders who have a claim on a specific piece of collateral. For example, a bank that gave the company a loan to buy a building has a mortgage on that building. When the building is sold, that bank gets paid first from the proceeds. After the secured creditors are paid, whatever is left goes to the unsecured creditors. This is a huge group, including suppliers who weren't paid for their goods, landlords, and bondholders. They all get in line and the remaining money is distributed to them, usually on a pro rata basis. This means if there's only enough money to pay 10 cents for every dollar that's owed, then that's what everyone in this group gets. 10 cents on the dollar. And who is at the very, very bottom of this list? The shareholders, the owners of the company. In a Chapter 7 liquidation, the shareholders get paid last. And in almost every case, the money runs out long before it gets to them. This is a critical lesson of corporate law and investing. As a shareholder, you have the potential for unlimited upside if the company succeeds, but you are the very last to get paid if it fails. Your entire investment can, and often does, go to zero. That is the risk you take for that potential reward. So this system, whether it's the rebirth of Chapter 11 or the finality of Chapter 7, provides a clear, predictable process for handling corporate failure. It prevents a descent into chaos and ensures that whatever value is left in the company is distributed according to a set of established, fair rules. It's a recognition that in a dynamic, capitalist economy, not every business will succeed. And creating a safe, orderly way for them to fail is just as important as creating the conditions for them to succeed. It allows capital, people, and assets to be reallocated from a failed enterprise to new, more promising ones. Bankruptcy, then, is the end of a corporate story. It can be a tragic end, or a surprisingly hopeful new beginning. It is the final dramatic act governed by a complex set of rules designed to bring order to financial ruin. But corporate law doesn't just govern the end of a company's life. It also governs how companies grow, not just organically, but by combining with or consuming each other. What happens when one corporate giant decides to buy another, swallowing it whole in a deal worth billions of dollars? This is the high-stakes, high-drama world of mergers and acquisitions. And it's a battlefield where legal strategists are the generals, and the prize is market domination. Mergers and acquisitions, or M&A, is the corporate world's equivalent of a royal wedding and a gladiatorial combat all rolled into one. Let's break it down. The terms are often used together, but they mean slightly different things. An acquisition is the simpler of the two. It's when one company, usually the bigger fish, buys another company, the smaller fish. Think of Amazon buying Whole Foods. Whole Foods still exists as a brand, you can still go shop there, but it is wholly owned and controlled by Amazon. The original Whole Foods as an independent company is gone, absorbed into the Amazon empire. A merger is supposed to be a merger of equals. Two companies, often of similar size, agree to come together to form a brand new single entity. Company A and Company B join forces to create Company C. In reality, true mergers of equals are incredibly rare. Almost always, even if it's called a merger, one company's management team and culture ends up being the dominant one. Think of the merger of Disney and Pixar. While it was framed as a partnership, it was fundamentally an acquisition where Disney bought Pixar to inject its creative DNA directly into its animation studios. So why go through all this trouble and expense? Why spend billions, sometimes hundreds of billions of dollars to buy another company? The reasons are as varied and as human as any other motivation. The most obvious reason is growth. A company can spend years, even decades, trying to build a new product line or break into a new country. Or it can just buy a company that's already done it. It's the ultimate shortcut. Instead of building a new factory, you buy the company that owns the factory. Instead of developing a new piece of software, which could take 5 years of research and development, you buy the scrappy startup that's already perfected it. Another, more ruthless reason: to eliminate a competitor. This is the corporate version of, if you can't beat M, buy 'em. The most famous modern example is Facebook. In 2012, they saw a tiny, fast-growing photo-sharing app called Instagram as a potential threat. So they bought it for $1 billion. 2 years later, they saw a messaging app, WhatsApp, gaining massive traction and threatening their own messenger platform. So they bought that for $19 billion. Facebook didn't just buy companies. It bought the future, ensuring anyone who left its platform would simply land on another one of its properties. But the magic word you'll hear thrown around in every M&A deal is synergy. It's a bit of a corporate buzzword, but the idea behind it is powerful. Synergy is the concept that the combined company will be more valuable than the two individual companies were on their own. It's the idea that 1 + 1 = 3. How? Well, first there's cost synergy. The new combined company doesn't need 2 CEOs, 2 chief financial officers, or 2 headquarters. It can combine its marketing departments, its HR teams, its legal departments. This, unfortunately, often means layoffs, one of the harsh realities of M&A. But from the company's perspective, it's eliminating redundant costs and becoming more efficient. Then there's revenue synergy. Maybe Company A is strong in the United States, and Company B is strong in Europe. By combining, they can now sell Company A's products to Company B's European customers, and vice versa. They instantly gain access to new markets and new customers that would have taken years to build on their own. This entire high-stakes process is where the corporate lawyer truly shines. They are the quarterback of the M&A deal. While investment bankers are figuring out the price, the lawyers are managing the entire complex, sprawling process of actually making it happen. Their first and most critical job is something called due diligence. This is the corporate equivalent of a full body scan, a deep background check, and a forensic accounting investigation all rolled into one. The buyer's lawyers descend upon the target company and scrutinize everything. And I mean everything. They read every important contract the company has ever signed. Are there hidden clauses that could cause problems later? They check the company's real estate leases. They verify that the company actually owns the patents and trademarks for its key products, the so-called crown jewels. They investigate any ongoing lawsuits. Is the company about to be hit with a $1 billion fine that nobody knows about yet? They check for environmental liabilities, tax problems, employee disputes. Anything and everything that could be a hidden bomb waiting to explode after the deal is done. They are looking for skeletons in the closet, and it's their job to find every single one before their client spends billions of dollars. While one team is doing diligence, another team of lawyers is negotiating the deal itself. They are drafting and fighting over the single most important document, the merger agreement. This can be hundreds, even thousands of pages long, and every single word matters. They argue over the price and how it will be paid. Is it all cash? Or will the seller get stock in the new company? They spend weeks negotiating the reps and warranties. These are legally binding promises the seller makes about the state of the business. For example, the seller represents and warrants that it has paid all of its taxes, that its financial statements are accurate, and that it owns all its intellectual property. If the buyer discovers after the deal that one of these promises was false, say a massive unpaid tax bill comes to light, they can sue the seller for breach of warranty. Lawyers will fight over every comma and qualifier in these sections, because millions of dollars can hang on a single word. Once the deal is signed, it's not over. The lawyers then have to shepherd the deal through a maze of regulatory approvals. In the United States, if a deal is large enough, it has to be reviewed by the Department of Justice or the Federal Trade Commission for antitrust concerns. The government's job is to make sure the merger won't create a monopoly that harms consumers by jacking up prices or killing innovation. Corporate lawyers have to build a compelling case, arguing to the government that the deal is actually good for competition and for customers. But what if the target company doesn't want to be bought? This leads to the most dramatic scenario in all of corporate law, the hostile takeover. This is when an acquiring company, the raider, bypasses the target company's board of directors and goes straight to its shareholders, trying to buy up a majority of the shares on the open market against the wishes of management. This is corporate warfare. And the target company's lawyers have an arsenal of defensive weapons at their disposal. The most famous is the poison pill. It's a shareholder rights plan designed to make the company incredibly difficult or expensive to acquire. For instance, if a hostile bidder acquires more than, say, 15% of the company's stock, the poison pill is triggered. This allows every other shareholder to buy newly issued shares at a massive discount, maybe 50% off. This floods the market with new shares, massively diluting the hostile bidder's ownership stake and making it prohibitively expensive for them to continue. It's like threatening to blow up your own ship to prevent pirates from capturing it. Another defense is to find a white knight. This is when the target company, facing a hostile bid from a company it despises, quickly finds a different, more friendly company to acquire it instead. The white knight rides in to save the company from the clutches of the hostile raider, usually by offering a better price and promising to keep the management team in place. From the initial strategic handshake to the deep dive of due diligence, from the marathon negotiation sessions to the public battles of a hostile takeover, the world of M&A is where corporate law is at its most complex, its most consequential, and its most thrilling. It is the process by which the entire landscape of our economy is shaped and reshaped, one multi-billion-dollar deal at a time. But what happens when the deal turns sour? When shareholders revolt, or when a company, even a massive one, simply runs out of road and collapses under its own weight? That's when corporate lawyers face their ultimate test: navigating the corporate graveyard. When a company enters the graveyard, it's not a quiet, peaceful affair. It's a chaotic, high-stakes scramble. Imagine a five-star restaurant on a Saturday night. The kitchen is a symphony of controlled chaos. Suddenly, the power goes out. The orders stop. The suppliers are at the back door demanding payment for the day's delivery. The diners are starting to get angry. The fire marshal shows up. Everything grinds to a halt. This is corporate collapse. And the corporate lawyer is the head chef, the manager, and the crisis negotiator all rolled into one, trying to prevent the entire building from burning down. The most well-known part of this graveyard is bankruptcy. The word itself sounds like a final judgment and admission of total failure. But in the world of corporate law, it's far more nuanced. It's a legal tool, a process. In the United States, this process is primarily governed by two chapters of the Bankruptcy Code, Chapter 7 and Chapter 11. Think of them as two completely different emergency rooms for a dying business. Let's start with Chapter 11. This is the corporate ICU. This is not about burying the company. It's about attempting a radical life-saving surgery. When a company files for Chapter 11, it's telling the world, stop. We are critically injured, but we believe we can be saved. We need protection from our creditors while we figure out a plan to heal. The moment that petition is filed with the court, a powerful legal shield called the automatic stay slams down. It's like a giant pause button on the entire financial world of that company. Lawsuits are frozen. Lenders can't foreclose on property. Suppliers can't demand immediate payment for past due bills. It creates a bubble of breathing room. Inside this bubble, the corporate lawyers work with a speed and intensity that makes M&A look like a leisurely stroll. Their first job is to get what are called first-day motions approved by the bankruptcy judge. This is the triage. They need the judge's permission to do the most basic things to keep the business alive. Can we pay our employees their next paycheck? If the answer is no, thousands of people walk out the door and the company dies on the spot. Can we continue to use our cash to buy essential supplies? Can we honor our customer warranties to prevent a mass exodus? Each motion is a desperate plea to keep the patient's heart beating. While this is happening, the real war begins. The war with the creditors. Every person and every company that is owed money lines up, and they all want to be first. There's a strict hierarchy. At the top are the secured creditors. These are typically banks that lent the company money and took a specific asset as collateral, like the company's headquarters or its valuable patents. They have a mortgage, a legal claim to a piece of the company. They get paid first from the sale of that asset. Below them are the unsecured creditors. This is everyone else. The suppliers who delivered raw materials on credit. The landlord. The marketing agency that ran their last ad campaign. They have no collateral. They're just holding an IO. And at the very, very bottom of the pyramid, the shareholders. The owners of the company. In a bankruptcy, their stock certificates are often worth less than the paper they're printed on. The corporate lawyer's job is to sit in a room with representatives for all these groups, each with their own high-powered lawyers, and hammer out a plan of reorganization. It's one of the most complex negotiations on earth. It's a brutal process of financial sacrifice. The plan might say, secured lenders will get 90 cents for every dollar they're owed. Unsecured creditors might get 20 cents on the dollar. And the old shareholders? They get wiped out completely, and new shares are issued to the creditors as a form of payment. It's about convincing everyone to take a painful haircut, arguing that a small piece of a living, breathing company is better than a slightly bigger piece of a dead one. If the lawyers can get enough of the creditors to agree and get the judge to approve the plan, the company can emerge from Chapter 11 leaner, restructured, and with a second chance at life. Many major airlines and car companies have gone through this exact process and survived. But what if the patient can't be saved? What if the wounds are too deep? That's when you enter the other emergency room. Chapter 7. This isn't the ICU. It's the morgue. Chapter 7 is liquidation. It is the formal legal declaration that the company is dead. There is no plan for reorganization. There is no second chance. The goal here is an orderly burial. When a company files for Chapter 7, the game is over. A court-appointed trustee comes in, and their job is simple. Sell everything. The office furniture, the computers, the delivery trucks, the patents, the customer lists, every single asset is liquidated and turned into a pile of cash. The corporate lawyers assist this trustee, ensuring the sales are done correctly, and the assets are properly accounted for. Then, that pile of cash is distributed to the creditors according to that same strict hierarchy. Secured creditors first, unsecured creditors next. And whatever is left, which is almost always nothing, goes to shareholders. Chapter 7 is the end of the road. It's the lawyer acting as an undertaker, ensuring the final affairs are settled before the corporate entity is dissolved forever. But failure isn't just about running out of money. Sometimes the collapse is triggered by a rebellion from within. Remember those duties of care and loyalty that directors and officers owe to the company? What happens when shareholders believe those duties have been violated? What happens when they believe the people in the boardroom drove the company into the ground through negligence or, even worse, self-dealing? They don't just sell their stock and walk away. They sue. This is the world of shareholder litigation. Another cornerstone of corporate law when things go wrong. Typically, this takes the form of a shareholder derivative suit. It's a fascinating legal concept. The shareholders aren't suing for their own personal loss. They are suing the directors and officers on behalf of the corporation itself. They are effectively saying, you, the board, have harmed the company that we own. Since you won't sue yourselves, we are stepping into the company's shoes to do it for you. These lawsuits are explosive. They allege that the board approved a disastrous merger without doing proper research, a breach of the duty of care. Or they allege that the CEO used company funds to buy a private jet for personal vacations, a breach of the duty of loyalty. The corporate lawyers are now in a defensive crouch. Their client is the corporation, but they are also defending the very directors and officers being accused of misconduct. The process is a grueling marathon of depositions, document reviews, and legal motions. The lawyers will dig through years of board meeting minutes, emails, and financial reports to prove that the directors acted in good faith, and with the information they had at the time. The personal stakes are astronomical. Directors and officers can be held personally liable for millions of dollars in damages. This is why corporations spend a fortune on something called D&O insurance, directors and officers insurance. It's a specialized liability policy that protects the personal assets of the leadership team in case they get sued. The battle over these lawsuits can define a lawyer's career, pitting them against some of the most aggressive plaintiffs' attorneys in the country. It's a fight not just over money, but over reputation, legacy, and the fundamental principles of who is accountable when a corporate dream becomes a nightmare. Whether it's guiding a company through the fires of bankruptcy or defending its leaders in a courtroom showdown, the corporate lawyer's role in times of distress is to bring order to chaos. They are the architects of second chances and the managers of final endings. But all of this, the deals, the collapses, the lawsuits, doesn't happen in a vacuum. There's a powerful unseen force watching over everything. A financial referee with the power to change the game entirely. We're talking about the regulators, the gatekeepers of Wall Street. And when they get involved, even the most powerful CEOs tremble.